The Arms Trade Treaty Baseline Assessment Project, or ATT-BAP survey, seeks to help states in three ways. First, it provides clear guidance on the provisions of the Arms Trade Treaty, or ATT. Second, it helps states to identify whether their existing arms transfer control systems fulfill ATT requirements and where elements might need to be developed or strengthened. Third, it serves as a tool to assist in the preparation of a state's party's initial report on measures to implement the ATT. ATT-BAP has developed this series of 9 guidance notes to provide online training and capacity-building tutorials to enable states to fulfill implementation of the ATT. The guidance notes can facilitate the completion of a state's ATT-BAP survey and its initial report on measures undertaken to implement the ATT. The online training and guidance notes provide examples of information that can be provided and advice on compiling information, such as the potential sources of information. This training and tutorial has 3 benefits. 1. It can guide government officials as they prepare their initial report on implementation measures. 2. Help to ensure that obligations are implemented. And 3. Highlight good national practices and understandings of ATT provisions.
The UK is a strong supporter of a robust, effective arms trade treaty. That's why we support the Baseline Assessment Project as an effective tool for encouraging states to make the first step towards full and transparent reporting.
Costa Rica does not export conventional weapons, but limits imports and have measures to regulate transit. We understand the challenges that important states face in light of the ATT provisions, and we believe the ATT Baseline Assessment Survey is a crucial tool for states in our situation to understand the treaty's provisions and demonstrate how to implement them. We're seeking to implement our national control system to effectively implement the Arms Trade Treaty. We're keen to share the experiences we are learning and the measures we're taking with our friends and neighbors in Central America. We encourage other states to fill out the survey and share their experiences, understandings, and good practices.
Narrowed things down in a very fundamental manner, which we're able to use and say, this is what we have to do in this particular area, this is what we need to do in the other area, and so on. And this is what we have been trying to encourage the other member states in CARICOM to do. And we will continue to do so after Cancun, because for us, the Arms Trade Treaty is primarily about saving lives.
The online tutorial has 9 modules. Module 1, National Control System and List. Module 2, Exports. Module 3, Imports. Module 4, Transit and Transshipment. Module 5, Brokering. Module 6, Prohibitions. Module 7, Risk Assessment. Module 8, Diversion. Module 9, Enforcement.
The ATT is a treaty of landmark proportion. It's revolutionary in many respects. So we are continuing to examine all facets of our legislation in order to ensure that there's effective and efficient implementation of the Arms Trade Treaty provisions, bearing in mind that not all pieces of our legislation would have catered for the Arms Trade Treaty.
In 2013, the UK reviewed its arms export controls to ensure they were compliant with the newly adopted Arms Trade Treaty. As a result of this review, we made 2 changes. First was to expand the UK brokering controls to ensure that they applied extraterritorially, so to UK nationals engaged in brokering activities outside of the UK. The second change was an expansion to the EU and national arms export licensing criteria, known in the UK as the consolidated criteria. We made several changes to these to bring them up to date, but very few substantive policy changes. Among the substantive policy changes we made were to include reference to the Arms Trade Treaty itself and to include reference to gender-based violence.
And we've been a strong supporter of openness and transparency in the register and in Wassenaar from the beginning, and we support it in the ATT context.
Module 1. National Control System and List. Which agencies maintain or update your control list?
In Austria, we have 2 line ministries. There's war material, so that's the heavy stuff, so to speak, from machine guns upwards to tanks. And there, the line ministry is the Ministry of the Interior. The rest, like small arms and light weapons and dual-use items, the lead ministry is the Ministry of the Economy. And they are responsible for assessing what sort of item this is. And the ministries use the control lists published by the European Union, and those are in turn based on the control lists of Wassenaar. We are part of a much larger process, which is Wassenaar and the European Union. So to make that very clear, the control lists of Wassenaar are published in English, and then the EU control lists are translated in all EU languages, amongst those German. We don't have the capacity to go through the German translation, but this is done by our German friends and neighbors.
Will you apply the provisions of the ATT to all items contained in your national control list?
We will apply it, and we are applying it to the entire control list. That was also something we wanted to in the ATT negotiations. Of course, we had to strike compromises, but nationally we are trying to be as extensive as possible.
Is your national control list publicly available?
These lists are publicly available on the internet. There's a website by the Ministry of the Economy. Well, the line ministry is of course shared with the companies, the stakeholders. It's available on the web, so it's transparent. There should be no problem.
States are required to establish and maintain an effective national system to control the export of conventional arms, related ammunition, and parts and components that assemble conventional arms covered by the treaty. The system must also regulate the import, transit, and transshipment and brokering, defined as transfers, of conventional arms covered by the treaty. States must explain how they fulfill these ATT commitments. In particular, states parties are obliged to establish and maintain a national control list that covers at a minimum the 8 categories of conventional arms outlined in Article 2(1) of the treaty text, as well as ammunition defined in Article 3 and parts and components that are used for assembling conventional arms as defined in Article 4. Some states use national control lists derived from those formulated by export control regimes, for example the Wassenaar Arrangement, or regional organisations that cover items beyond the scope of the ATT. Some states have control lists that do not include all of these items contained in Articles 2, 3 and 4 of the ATT. Module 2. Exports. Which agencies are responsible for implementing controls on arms exports?
The U.S. National Control System is a very elaborate and complicated system. It's more complicated than most people's are. So although we like to think that we have the gold standard for the system, we don't actually wish to inflict our system on everybody else because it's much more complicated than what they need to have. Because as the largest arms exporter in the world, we also have a great deal of responsibility for what we do, and we need to have a strong and effective national control system. One of the umbrella laws is the Arms Export Control Act, but there are a series of laws and also regulations. Well, the U.S. National Control System requires that for you to import or export conventional arms, you actually have to have a license and authorization, and it's very detailed and very cumbersome. But we think it's effective. The United States believes that its export control system is already fully consistent with the obligations of the treaty. That the system that we already had in place before we started the negotiation is fully compliant with all the obligations, and all that we have to do to comply with the requirements of the treaty is actually to submit the reporting to the treaty, the reporting on the national control system and then on the actual authorizations and items transferred. But we didn't have to change our system at all because we've assessed that it's compliant with the requirements and obligations of the treaty.
There's quite a number of them that are involved, ranging from Defense Department, the Department of Foreign Affairs, State Security, the Police Service, as well as the Department of Trade and Industry. So those are departments basically involved in the arms transfer process. Well, it's basically the Department of Foreign Affairs, obviously supported by the Arms Control Authority.
Is the relevant legislation located online?
The two places to start with in terms of getting this kind of information from the U.S. side is probably in the State Department, the Bureau of Political Military Affairs, and the website for the Directorate of Defense Trade Controls, or DDTC, because they handle the commercial side of the arms exports, or to go over to the Department of Commerce, Bureau of Industry and Standards, or BIS is the acronym for it, where they have a series of websites there with information on this as well.
Well, it is publicly available. It is on a website, and you can get that from any government department that handles this kind of document. So it's a publicly available document. Well, in South Africa, we've got what is called the Government Printing Works, which basically handles all documents of government in terms of printing. But at the same time, all government departments that have got a role to play with regard to the arms transfer authorization will have access to this particular documentation.
Does your state's legislation or regulations outline the measures to ensure that authorizations are detailed and issued prior to export? What are the measures?
It's largely a national process, but it therefore benefits from inputs from our regional partners or any other person who seeks to buy weapons from South Africa. As an example, if there are certain regional initiatives on a particular thing, that would be part of our consideration process before a decision is made. But final decision is a national discretion, and as such, therefore, we take into account quite a number of factors. But at the end of it all, it's the discretion of South Africa that prevails.
How does your state fulfill its record-keeping obligations under the ATT? Does it keep records of authorizations and exports?
In the sense that before you can get a license, there is a particular set of information we have to provide, ranging from the objectives for which you buy the weapons, right up to assurances we have to provide, as well as undertakings about the future use of the weapons. So basically there is a whole set of information that we have to provide before a decision is made. Well, we are required by national legislation to have to keep records for a particular period of time. Currently, it's about 8 years with respect to arms. However, we are intending to amend that to ensure that it is aligned with the record-keeping period of the ATT.
Can the records be accessed to inform future decisions on authorizations?
Well, when we report data to Wassenaar and to the UN Register, we report on the actual items transferred to it. We collect information on both authorizations and on actual items transferred because under those two things, as I said, we actually have to report on the actual items transferred, but we also report to Congress on authorizations. So we collect information on both sides of the equation. But we make it available to other states through the Wassenaar arrangement or to the UN Register, but then the congressional reporting that we do in the 655 report and various other things, that's all publicly available information. Well, as the largest arms exporter in the world, it's not easy for it. We have an elaborate control system which we use for it, but we have, depending on the year that you're talking about, somewhere between 40 and as much as 60% of the international arms trade, in terms of on the export side at least. So we have to collect the data, and collecting the data, I know from personal first-hand experience with the UN Register, for example, that we break the data into commercial sales and government-to-government transfers, and on the government-to-government transfers to collect that data, we have to go to as many as 35 different offices to actually collect the data because although we prepare these reports, we don't actually have a central repository with all this information automatically brought into one place. And for some of the smaller or countries with smaller exports, and it might be easier for them to do this, but we have the responsibility spread over a number of different agencies. So we have to go to those agencies to get the data from them.
It's kept in different forms. Basically, there are hard copies of the information. It's based or it's included in our database, which is electronic. And as such, therefore, before any decision could be made on arms transfers, we run a profile on the country that we wish to sell to. And as such, therefore, we have access to about everything that we have on that particular country.
Can the records be easily retrieved for reporting?
We make it available to other states through the Wassenaar Arrangement or to the UN Register, but then the congressional reporting that we do in the 655 report and various other things, that's all publicly available information.
Given the current obligations that we have of reporting, firstly to Parliament as well as to Cabinet, so for us, retrieving the information is not difficult at all because the information is readily available and we are doing reporting all the time. So to fulfill our reporting requirements under the ATT would not present an enormous challenge.
In order to explain how states fulfill their ATT commitments with regards to the establishment and maintenance of an export control system, states must provide information on export control legislation. This may be a single act and related secondary legislation and policy guidelines, or a range of different laws. Competent national authorities or agencies designated as responsible for implementing controls on arms exports. States take different approaches to fulfilling this obligation, and it can include a single ministry or a specialized agency responsible for export controls. In some cases, it can be an inter-ministerial committee. The authorization process. States must take measures to ensure that all authorizations for the export of conventional arms covered under Article 2(1) or of items covered under Article 3 or Article 4 are detailed and issued prior to the export. And record keeping for transfer authorizations and/or actual exports. The ATT only provides an indicative list of information that could be included in such records, so it's useful to show what information is retained in your national records. Good record keeping is useful for conducting risk assessments and also important for enabling the compilation of annual reports on arms export authorizations or actual exports. Of course, an effective and transparent export control system is essential for implementing Articles 6 and 7 of the ATT on prohibitions and risk assessment, which are dealt with in Guidance Notes 6 and 7. Module 3. Imports. Which agencies are responsible for regulating arms imports?
The Trinidad and Tobago Customs and Excise Division, and working in collaboration with the Trinidad and Tobago Police Service.
Is the relevant legislation located online?
They are found online. The attempt is to ensure the citizens of Trinidad and Tobago are aware of the controls relating to import of arms, and this predated the adoption of the Arms Trade Treaty.
What measures does your state take to regulate imports?
The measures which are taken to regulate imports would require the importer to obtain certificates for importation by the relevant agencies, Customs and Excise, Trinidad and Tobago Police Service, and I believe there are obligations to provide this information in the form of a report, which comes from the importers.
Does your state have an import system? What kind of system does your state have?
Well, the import system for Trinidad and Tobago might be a bit different from, let's say, those who import a significant number of conventional arms. Our conventional arms are largely imported for the protective services and the military, and they are also individuals who have who have license to ordinary citizens to hold firearms. So our import system is it's fashioned in such a manner to ensure that there is no diversion of conventional arms from the destined to the legal market to the illegal market, bearing in mind that diversion is difficult to prevent 100% of diversion on a day-to-day basis.
What measures does your state take to ensure that appropriate and relevant information is available to exporting states?
Those agencies charged with the responsibility for the regulation of the imports of conventional arms, for the licensing of conventional arms, and for the prevention of diversion of conventional arms, they would liaise with the exporting state to ensure that as many gaps or as many loopholes are clogged as possible.
Does your state keep records of its imports? What information is contained in the records?
The imports which would be recorded would be those which are authorized, and those which are authorized for official purposes would be actual imports.
States must demonstrate how they fulfill their ATT commitments with regard to the establishment and maintenance of a system for regulating imports. They must provide information on legislation that regulates imports. This could be contained in the same legislation for controlling arms exports or regulating other types of transfers, or could be in a law on arms or customs or foreign trade. Relevant agencies to regulate imports. There are many different national approaches for regulating imports. Measures to regulate imports. This can include measures to ensure that appropriate and relevant information is available to exporting states as part of their export assessment process, including by providing documentation on the end use and/or end user. And record keeping for transfer authorizations and/or actual imports. The ATT only provides an indicative list of information that could be included in such records. It's important that records of imports provide information to enable the submission of an annual report on arms import authorizations or actual imports. Module 4. Transit and Transshipment. Which agencies are responsible for regulating arms transit and/or transshipment?
For the Philippines, transit and transshipment, and in general border security, really is the business of customs. But nothing in the Philippines is really ever the responsibility of just one agency. So there's customs, and then there are other agencies who are involved, such as Coast Guard, the ports authorities, local government, the police, especially if it's arms related, it's always the police, the military, Department of National Defense, and other. So it's an interagency effort, and there are about 10-15 agencies that you have to get together in a round table in order to get the answers, especially for transit and transshipment policies for the Philippines.
Is the relevant legislation located online?
The legislation for transit and transshipment, it isn't really up to the standard of the ATT yet, but the one that we have is available online, not on a government website, but there are certain online databases that provide this. But there are agency policies that support also that legislation, because it's, in general, it's a customs code where transit cargo is defined. And then we also have an upcoming bill that aims to implement about 95-98% of the Arms Trade Treaty, where transit and transshipment are clearly defined, not just in accordance with the ATT, but also in accordance with certain export control regimes, such as the Wassenaar Arrangement, the Nuclear Suppliers Group, and so on and so forth. So it's available, but certain policy directives have to be requested from customs or other specific government agencies. With the bill that we're proposing in Congress to define it according to ATT terms and, add additional requirements, especially for the criteria.
What measures does your state take to regulate transit and/or transshipment?
Because certain items are controlled by different implementing agencies. For small arms and light weapons, it's the National Police, and they give the directives. For conventional arms, it's the military. So it's a bit peculiar for the Philippines because while small arms and light weapons, the government gives access to certain civilians or other specialized civilians with occupation or jobs that require the use of small arms and light weapons. The conventional arms is for the exclusive use of the military and national defense. So there are certain directives, like, for example, for small arms and light weapons, definitely the documentation requires end user agreement, details about the end user, such as the name, the company information, the background, the end use, the quantity, the model, the type, the item, so on. It's descriptions about the item in general. But for the military, because the only agency in the Philippines that is allowed to use or procure conventional arms is the military, generally they procure it from government-accredited agencies. So there's usually very little detail that is required, at least for conventional arms. But for small arms and light weapons, these documentations, and then some background checks also done by National Police in coordination with other governments, with intergovernmental organizations, with Interpol, for example, whenever necessary. Importers and exporters, whether or not they import or export, if they do transit, transshipment, even brokering activities, they still have to get accreditation from customs, and that is passed on to the relevant implementing agency, such as for small arms, it's the National Police, and then conventional arms for the military. So that still it requires some clearance from the responsible agencies. Just for sea, there isn't anything at the moment for air, although we are trying to upgrade that with the upcoming bill. For land, because we're surrounded by water, we're an archipelago, nothing for land, but sea is the primary, the primary transit or transshipment medium for the Philippines.
Does your state apply risk assessment criteria to transit and/or transshipment authorizations?
At the moment, the risk assessment is very slim, but we are planning to upgrade that to something that is more specific, and not just the criteria or the risk assessment proposed in the ATT, but other export control regimes as well.
Does your state keep records of transit and/or transshipment authorizations? What information is contained in the records?
Yes, we keep records. We keep them for 10 years or more. The minimum is 10 years. If there is an outstanding case, and we never delete it forever and ever until the case is resolved. But yeah, we do keep records of transit and transshipment transactions or requests. Exporter or importer, the ones requesting the transit or transshipment transaction, the end user, whatever the end use is, the type of the item, the quantity, the model, and other details about the shipment, the country where it's from, the country of destination, and other details too.
What steps has your state taken to fulfill ATT obligations with regards to transit and/or transshipment?
There's an effort at the moment because in the Philippines there are many law enforcement agencies for specific issues. Like there's a law enforcement for drugs, there's law enforcement just for customs. The Justice Department has its own law enforcement arm. Then there's the National Police. There's law enforcement for transnational crime. So there's an effort to get all these agencies together and form a single network where it'd be easy at least for those requesting, to channel the required documents for transit and transshipment requests. If there needs to be something that should be checked, like background, especially for the country of destination and the country of origin. So there's this interagency effort also that is being beefed up.
States must describe the measures that they take where necessary and feasible to regulate the transit and transshipment of conventional arms, including information on relevant legislation, which could be the same legislation for regulating arms transfers. This legislation may define the forms of transit or transshipment subject to regulation. Relevant agencies, which may or may not be the same as for regulating other arms transfers. Measures to regulate transit or transshipment. It's useful to indicate if all forms of transit are regulated, land, sea and air, or if different forms of regulation are in operation. And states are also encouraged to keep records of authorizations for transit and transshipment. Module 5. Brokering. Which agencies are responsible for regulating brokering activities?
Within the UK system, the Department of Business, Innovation and Skills, which is the equivalent in many jurisdictions of the Department of Trade, is responsible for arms export licensing. So the Business Secretary has ultimate responsibility for authorising export licences. However, there is an interagency process within the UK for consulting on these licences. So often a licence is received by the Department of Business, Innovation and Skills, but then the Ministry of Defence, the Foreign and Commonwealth Office, the Department for International Development, among others, are consulted before any final licensing decision is taken, and the ultimate authority for taking the decision lies with the Business Secretary. However, the enforcement of arms export controls lies with our Customs Authority, which is Her Majesty's Revenue and Customs within the UK.
Is the relevant legislation located online?
All information about UK export controls is available on the UK government website, which is www.gov.uk, and is searchable via commercial search engines. That means if you're looking for something specific in UK legislation, you could just type it into Google, and 9 times out of 10, the page you're looking for will come up under a commercial search engine.
What measures does your state take to regulate brokering?
On brokering for the Philippines, we do have a law requiring brokers to register with customs. But brokering at the moment in Philippine law is not up to the standard of the ATT. So we also have to redefine it. We have to criminalize illicit brokering, which is all in the new bill that we're planning to propose in Congress.
What is your national definition of brokering?
Well, brokering to South Africa is defined in legislation, but basically we say if there is a service that is provided by a South African citizen which has got a relationship with controlled items, such a person may have to go and get a license before he renders such a service. So that is how we basically deal with the issue of brokering. If a South African, therefore, in a process of brokering, therefore arranges a deal between various parties, whether in South Africa or outside of South Africa's jurisdiction, there is a requirement for a license to be obtained, and on the basis of such a license, therefore, you can start to conduct your activities.
States must outline the measures used to regulate brokering taking place under its jurisdiction, including information on legislation that addresses arms brokering. This could be the same legislation for regulating arms transfers. Providing information on the definition of arms brokering activities or arms brokers is useful to other states, especially with regards to enforcement. Relevant agencies charged with regulating arms brokering. Often, these are the same agencies charged with controlling exports and regulating other forms of transfers. And measures to regulate brokering, such as registration and licensing for transactions. Module 6. Prohibitions. Which agencies are responsible for implementing prohibitions of arms transfers?
Well, it was basically one agency. It was the Export Control Policy Division at the Department for Economics. And that is the main point of contact for all licenses, export control licenses that you need in order to export arms, and is also responsible for the political process in order to get the license through or approved.
Are prohibitions contained in relevant legislation or policy guidelines?
Absolutely. We have the number one prohibition in our War Material Act, which is the national legislation on the export of arms, of conventional arms. And there, number one, it's written that you should not authorize any export that is in contravention to international agreements. So, which means that basically you can now quote the ATT directly as a means in order to avoid a transfer. But you also have the War Material Ordinance, which is more concrete and says that there are further prohibitions. Number one, the first prohibition is you cannot export arms if the destination country is involved in an armed conflict. Number two, if it violates systematically and seriously human rights. And number three, if there is a high risk that the weapons will be used against civil population.
Is the information on prohibitions publicly available?
Absolutely, it's publicly available because it's a national legislation, and I can say that the practice really fits the national legislation, so there's nothing hidden about that. You can find it on the webpage of the State Secretariat for Economic Affairs. There you have a link to the national legislation, and there's also a non-official translation in English, which anyone can use as a template or in order to cross-check.
Does your state have specific legislation to implement UN arms embargoes?
We have the Embargoes Act, which is an act on the national, as part of the national legislation that is really meant to implement all the embargoes that are taken on the international level, but also on the national level. What is important, it is superior to the War Material Act, which means if there is anything prohibited under the Embargo Act, there is no export whatsoever.
How does your state interpret international agreements for Article 6, brackets 2?
Switzerland interprets widely, which means that there are many conventions that fall under Article 6.2, namely CCM, certain protocols to CCW, the Landmine Ban Treaty, etc.
How does your state interpret international agreements for Article 6, brackets 3?
For Switzerland, it's basically everything that's out there. So you can start with the Hague Conventions, go on to the Geneva Conventions, and especially one of the most important conventions is the Rome Statute.
How does your state interpret knowledge in Article 6, brackets 3?
The state concerned shall not authorize the transfer if it has reliable information that provides substantial grounds that the transfer would be used in the commission of the enlisted crimes. The first point is the reliable information that provides substantial grounds. Here we have to admit that you never have 100% certainty. It's always a question of intelligence gathering that is never 100% sure, but it's really about reliable information, which means reliable, does it make sense? Is it coherent with the other information that you have? And also, is it coherent with different information that you had for previous decisions? Now, I would emphasize that although we rely much on official intelligence provided by our intelligence service or by partner states, I would say that the most important information still is open source information. And if you can check that seriously and just check if it makes sense, then you've done already a good job.
How does your state ensure it does not authorize a transfer that is prohibited under Article 6?
Basically through organizational means, which means, number one, you consultate different offices for export licenses, which means you're at the State Secretariat for Economic Affairs, you reach out to the Ministry of Foreign Affairs, you also reach out to the Ministry of Defense, and you also consult the intelligence service. So that gives you a sense of different perspectives that you then can put together with all the different knowledges and the perspectives, like the human rights specialists, the international security specialists, the trade specialists, etc., etc. The second part is, of course, hierarchy, which means as a desk officer, you have to report to your boss. But then the more important the decisions are, the higher the decision-making instance will be, which means in Switzerland, the toughest questions go to the Federal Council, the Swiss government, which means that in the toughest cases, you have the highest standards of transparency.
Article 6 outlines the 3 sets of prohibitions contained in the ATT. States are prohibited from transferring conventional weapons if the transfer would violate obligations under measures adopted by the UN Security Council under Chapter 7 of the UN Charter, in particular arms embargoes, would violate relevant international obligations under international agreements to which the state is a party, in particular those relating to the transfer of, or illicit trafficking in, conventional arms. If the state has knowledge at the time of authorization that the arms or items would be used in the commission of genocide, crimes against humanity, grave breaches of the Geneva Conventions of 1949, attacks directed against civilian objects or civilians protected as such, or other war crimes as defined by international agreements to which it is a party. Therefore, states must provide information on whether the state prohibits arms transfers in the given circumstances, and in particular the relevant international agreements to which it is a party. States might also have other circumstances under which they prohibit arms transfer authorizations, and should share this information with other states too. Module 7. Risk Assessment. Which agencies are involved in conducting risk assessments for arms transfers?
We collect, depending on the license of the item being transferred and the recipient, we get information from essentially the entire U.S. government, Department of Commerce, Department of Defense, Department of State, Department of Justice. We get information from all of them, but then we also get information from our intelligence community, and we bring it all together. So it's a pretty broad-based information. Now, not every license or authorization requires this full range of information, but there is, again, there's a healthy interagency process to review licenses and to work on the risk assessments.
Our arms control process is basically inclusive of all relevant government departments. As said, there's trade and industry, there's defense department, there's state security, there is police, there's as well as customs. And if an application comes through, we therefore receive every specific line function input from all the government departments. And obviously, those that have got a particular concern about a particular application will therefore enlist that. And as such, therefore, if there are risks that are arising out of that process, we tend to look at that very carefully.
Are risk assessment criteria contained in relevant legislation or policy guidelines?
The risk assessments, the criteria for the risk assessments are contained in the recently updated conventional arms transfer policy. It specifies a series of criteria in the policy.
We have, in terms of our act, which is the National Conventional Arms Control Act, we've got a particular section which sets out the criteria or guidelines for arms transfer. They range from obligations that we have under international treaties, to human rights, to security, to embargoes, to all kinds of things. And when we do an assessment of an application, it is done against that particular profile. And as such, therefore, if there are areas which are of concern as you apply that particular criteria, therefore you may highlight that as a risk and begin to look at measures you will adopt to try to mitigate such a risk.
Can records be used to inform risk assessment?
Yeah, I mean, as part of the licensing and authorization decision, we look at prior licenses that we've granted and considering future licenses, and including whether a license, that's been previously issued, whether it's been suspended or something.
Is the information on risk assessment criteria publicly available?
It depends on the nature of information that you have at any given moment in time. There will be information that is publicly available, but there is some information that will be very sensitive, and as such, therefore, would observe standards of confidence when it comes to that. It's case by case, but everyone therefore should know that there is a legislation that everyone has got to comply with. So the Section 15, which I've referred to earlier, is basically publicly available. So you know the standard against which you shall be charged.
Which agencies are involved in risk mitigation?
Essentially, the same agencies that are involved in the licensing process are also involved in the risk mitigation process, because part of the licensing process, if we identify a risk, then in order to go ahead with the authorization, we then need to identify a mitigation measure for it. And the mitigation measure, it can involve Department of State, it can involve Department of Defense, Department of Justice. It just depends on the nature of what the mitigation measure might be. For example, we might identify a potential risk with a particular recipient country that they have a poor record on stockpile security or something, but we could then export the item in question to a particular entity within that government that has a better record on stockpile security and stockpile management, and then possibly again do post-shipment verification to follow up on the actual transfer to make sure that it's where it's supposed to be. But we do this on a regular basis, not with every single transfer, but we do a great deal of post-shipment verification under the Blue Lantern program, Golden Century, and other programs.
We may have a risk, like as an example, a risk of diversion. If a person, therefore, we suspect that there is a risk of diversion, we may have to get into some arrangement with them around, as an example, the post-delivery inspection arrangements. So that after a particular period of time, we may have to go to that country and wish to see the items that we exported to them and see whether such use is still consistent with the originally declared end use.
What are examples of risk mitigation measures your state undertakes?
Well, it depends on the nature of the risk that you have. If there is a risk around a possible diversion, will therefore require Foreign Affairs to be able to engage with the country of our destination and seek to get some assurances with regard to that. But some would be basically be in the area of defense, as an example. If probably the intended use of the weapons is inconsistent with what we think is correct, we may therefore have to ask our Defense Department officials to look into that. But obviously, once such information is basically obtained, it fits into the system again for everyone to consider and look at the extent of the mitigations, whether it is indeed sufficient to deal with the risk.
How does your state interpret overriding risk?
Well, any state which does arms export, as part of their export decision, they basically they do a balancing of risk, essentially costs and benefits. What are the potential risks of the transfer, and what are the benefits of the transfer? Why are we considering doing the transfer in the first place? And you would include then economic factors alongside, the positive security benefit from the transfer, and you'd weigh that against the risk. And the overriding risk, it doesn't do with how high the bar gets set for that. It has to do with this balancing act. And if you identify that the risks are greater than the benefit from the transfer, then that would indicate that you shouldn't go ahead with the transfer. But if you find that the benefits outweigh the potential risks, then you could go ahead with the transfer. And you might need to, again, oppose mitigation measure if you identify risks in the risk assessment. But it's basically talking about a balancing act of weighing the benefits from doing the transfer. Again, could be economic, could be security, versus the potential risks from going ahead with the transfer.
Well, to some extent, it will be a matter of interpretation. If you apply the criteria, there are some risks that will be too high that you may feel that whatever arrangements or mitigation you can put into place may not be sufficient. An example of that, it's the biggest risk. If there's an arms embargo on a particular country, to us is an overriding risk. If there is a risk about commission of acts of genocide and related crimes, to us that will constitute an overriding risk. If there's an issue of internal suppression, which is systematic, those would constitute the overriding risk in our instance.
What sources does your state use to inform risk assessments?
You look into various sources of information. Firstly, there will be open source assessment, but sometimes we may have to rely on our diplomatic agencies to basically look into that, and to some extent, therefore, there will be some intelligence gathering that states will do from time to time. So, in combination, all these sources of information will be considered depending on the nature of the risk that we're dealing with.
Does your state apply risk assessment criteria to transit and/or transshipment authorizations?
Because we apply the risk assessment to the items that we're actually transferring, that we're actually sending out. And we obviously don't have a risk assessment on the import side, which is not required by the treaty. So we don't apply the criteria to transit and transshipment things. But if we know, for example, that a transfer that's going to transit the U.S. is going to somebody who's under a UN arms embargo, then we would take action on it. But that's not part of an assessment. That's just checking to make sure that it's consistent with international law.
Well, it is applied to about all the transfer activities. To us, whether it's a transshipment, whether it's export, whether it's import, whether it's brokering, we apply the same standard.
States should demonstrate that they fulfill their ATT commitments with regard to the risk assessment for export decisions. Therefore, states must firstly indicate that prior to granting an export authorization, they assess and act upon their assessment of whether the arms, ammunition and parts and components would contribute to or undermine peace and security, could be used to commit or facilitate a serious violation of international humanitarian law, could be used to commit or facilitate a serious violation of international human rights law, could be used to commit or facilitate an act constituting an offence under international conventions or protocols relating to terrorism to which the state is a party, and could be used to commit or facilitate an act constituting an offence under international conventions or protocols relating to transnational organised crime to which the state is a party. Additionally, in making assessments prior to export authorization, exporting states must take into account the risk of conventional weapons being used to commit or facilitate acts of gender-based violence or violence against women and children. Exporting states must also assess the risk of diversion of exports of conventional arms. If states have utilized other criteria in their risk assessment process, these additional criteria should also be explained. States should also provide information on the risk assessment processes, and in particular if mitigation measures are part of their system, and if yes, what types of measures are regarded as legitimate risk mitigation measures. Module 8. Diversion. Does your state take preventative measures to mitigate the risk of diversion?
Coast Guard, for example, conducts a tremendous amount of surveillance in our archipelagic state, because Trinidad and Tobago, two main islands, Trinidad and Tobago, but there are a number of small islands as well associated with the state of Trinidad and Tobago. So surveillance by the Coast Guard, surveillance by the police, very importantly the Customs and Excise Division, and the National Operations Center as well, which is a coordinating mechanism of different agencies which are responsible for security and safety of Trinidad and Tobago, would put apparatus in place to address this question. When illegal arms are found, small arms and light weapons and so on, the agencies, the police service, the Customs and Excise Division would also have a register on arms confiscated, and this is important as well because we belong to an inter-American system. We also belong to the Caribbean community, and the implementation agency on crime and security in CARICOM impacts collates the information with regard to imports, whether the imports are illegal and so on, to share this information among the 14 member states, the 15 member states of CARICOM, to ensure that all the agencies in national territories are able to provide, are able to have this information, simply because that without having this information, it will be difficult to implement in a full manner the crime and security strategy for CARICOM, which was agreed to by the heads of government of CARICOM some time ago.
We insist on arms be transported across Costa Rica to be escorted by the police from point of entry to point of destination or departure in the case of transit. Arms that enter Costa Rica's ports must remain in the port of the custom area. We're currently working on guidelines to strengthen our control of re-exports that will greatly contribute to detect and prevent diversion.
Preventing or mitigating the risk of diversion is a critical issue for many states. Article 11 of the ATT provides an indicative list of measures that could be adopted to prevent the risk of diversion to the illicit market or for unauthorized end use and end users, including risk assessment prior to authorizing an export, mitigation measures, and international cooperation and information sharing. Therefore, the initial report on measures undertaken to implement the ATT provides a great opportunity to share good practices to prevent or mitigate the risk of diversion, as well as measures taken when a diversion has been detected. It is also a key area in which effective forms of international cooperation could be shared. Module 9. Enforcement. Which agencies are responsible for enforcing arms transfer controls?
Mostly the survey was completed by consulting with other ministries that sort of own the relevant legislation. So the Ministry for Justice, the Ministry for Finance, the licensing authority, a number of agencies, because the legislation that governs enforcement is spread out. As far as possible, we want to use the normal national legislation on criminal offenses. So, for instance, if someone falsifies an end-user certificate, we would use the normal criminal law for that. But there are some specific items that are in the law for export control. So when we were doing this, we needed to talk to our licensing authority, who are responsible for monitoring certain kinds of offenses, and we needed to talk to our normal criminal law bodies, who are responsible for enforcing the normal body of criminal law.
Is the relevant legislation located online?
We have a national website for the licensing authority, and then there's the general government website for general legislation. It's publicly available, and the way our legal system is set up, John Public is supposed to be aware of the legislation. It's not an excuse to say, oh, I didn't know that was criminalized.
What measures to enforce transfer controls are included in relevant legislation or policy guidelines?
And some of the enforcement clauses are in the actual legislation for exports. But most of it is simply our normal criminal legislation. So, for instance, if you falsify an end-user certificate, there's nothing specific in the export control law about that. We just fall back on the general legislation in the area. So apart from the licensing authority for the export control specific penalties and criminalizations, we have the police, the ordinary prosecution agency, the Ministry for Justice. There could be, from time to time, involvement of financial authorities, such as those in investigating financial crimes. So there's a host of different legislations that need to be described, at least in the form of an overview, that the measures and the penalties are spread all over our legal system, because we want to make use of the general criminal law as much as possible, rather than duplicating it in each area. So there are a few specific elements that are mentioned in the legislation on export control, but most of it comes out of our general legislation.
As I mentioned, in the Philippines, enforcement is kind of fragmented. So we have to form interagency bodies, but of course that takes time to convene and for them to deliberate and so on and so forth. According to that bill that we're planning to pass in Congress, there will be a central agency called the Strategic Trade Management Office that will manage all activities related to the Arms Trade Treaty, not just transit and transshipment, but import-export, re-exports, brokering, and other types of transfers. So there will be a central agency, and they will be linked up with all the other implementing agencies, customs, police, military, defense, justice, and the other law enforcement agencies will have to go through the central agency. So it will. The plan is really to create an interagency, interbody unit that will be more efficient for government and will also be more, at least less time consuming for the industry and other players who are requesting for those permits or authorizations.
The enforcement, like any other legislation, if there's a crime that has been committed, there is a particular enforcement process that you follow. You shall have a detection of a possible crime. You shall have the police to investigate that. You may have to ask your prosecuting authority to make a determination whether there's a case to follow. And if there is a case to follow, prosecution will happen, and there shall be a judgment given, whether it's imprisonment, whether it's a fine. But there is a whole regime that is in place to deal with possible offences under a legislation.
States must explain how they fulfill their ATT commitments with regard to enforcement. States must provide information on the relevant agencies for enforcing arms transfer controls and preventing or addressing diversion, measures for enforcing national laws and regulations that implement the provisions of the treaty. This can include sanctions and penalties at both the administrative and criminal levels.